1 is now in session.
Thanks, everyone. You can be seated. Good morning. We're on the record in our CV 240445, Legacy Interest LLC, Devron LLC, El Rio Community Association, and Thomas and Nancy Moss. As you know, we are recording and live streaming these proceedings, so please announce your name and who you're representing when you come to the podium. You each have 20 minutes per side. You're not required to use all of that time. We do require you to keep your own time if you want to reserve any. Please keep in mind we've read the briefing, studied the record, and conferenced this case just this morning. And with that, you may proceed.
Thank you, Your Honor. Amy Sells here for the appellants. I have with me in the courtroom my colleague, Frederick Cook. I'd like to reserve as much time as I possibly can for rebuttal, but I understand that you all might have a lot of questions for me, so we'll see how matters unfold. It's the genuine desire of my client that your determination here in this case today will put finality on this dispute that has been ongoing between the parties for about 8 years. But not only that it will give some stability and guidance to the remaining members of the community. In reviewing for today, it occurs to me that there really is just one very big question that everybody needs to know the answer to, and that is, did Mr. Hoover have declarant rights to assign to Mr. Graham in light of the criminal proceedings? We know that, but for the criminal proceedings, yes, he did have those rights, because if you look at the CCNRs, the declarant is ERCC, and the CCNRs give ERCC the right to assign out to any third party any of his rights under the CCNRs.
The question that I have looking at this case is, what is a receiver in all of this? It seems like once bankruptcy was declared and all the plea agreement went into effect, the receiver had all the rights, duties, and responsibilities that Mr. Hoover had.
Yes, and that's what I wanted to get into, because the association says that the analysis of this question begins and ends with the plea agreement. It begins with the plea agreement, sure, but there are other documents and filings that took place in the criminal proceeding that are just as important. So in the plea agreement, you see that Mr. Hoover is to turn over his assets, which include his property as well as his entities, to either a U.S. Marshal or a receiver. And in the plea agreement, it actually calls out ERCC and says that includes ERCC and ERCC's declarant rights. But then the question becomes, well, is it going to be a marshal or is it going to be a receiver? So then the prosecutor files a motion to appoint the receiver. And in that motion, it says a receiver has to be appointed here to allow the receiver to manage to liquidation the assets of Mr. Hoover. Okay? Now, we know under Arizona law that the scope of the receiver's authority is found within the four corners of the order appointing receiver. A receiver enjoys judicial immunity of the judge as long as he's acting in accordance with what's in the four corners of that order appointing receiver. If he acts outside of the four corners of that order appointing receiver, he's opening himself up to personal liability. So here, when you look at our order appointing receiver, it specifically says that the receiver is a liquidating receiver, and actually says, quote, the duties of the receiver shall be specifically limited to the liquidation of the subject properties and entities. So when that would make sense why it is then when the association went to the receiver and when Mr. Graham went to the receiver and said, I don't have declarant rights, do you have declarant rights? The receiver said, whoa, I'm not your guy, I'm the liquidating receiver.
Well,
So to answer your question, can I?
no, please.
To put a pin in that. So what happens when the receiver is appointed over an entity? Let's just say that the order appointing receiver allows for a receiver to step in. He steps into the shoes of the entity's principal for purposes of managing and controlling that entity. So unlike what I believe the association's position is, the plea agreement didn't just suddenly strip the principal of the entity of the principal's legal status. Here, because a receiver wasn't actually appointed over ERCC, the status quo remained. And so that meant that Mr. Hoover.
But isn't acting as a declarant necessary to liquidation, though? I mean, isn't it all of a process to liquidate? You my question was, aren't the duties and responsibilities of a declarant necessary? Wouldn't it have been necessary to the receivers to do to liquidate?
Not necessarily, because you can have declarant rights. One can have declarant rights over property that he or she doesn't own. So you could have a declarant, and then a separate entity might own a property.
Okay.
So here what we have is something really curious, right? And then that's why folks were not sure what to do. And so then you have Mr. Graham, who is this gentleman who.
Hey, Counsel, excuse me for interrupting you. We've already gone through like 6 of your minutes here. I got 2 follow-up questions on this arising out of what you've just said. So first, this surprising in this record, some of the things that aren't of record in several different lanes, including the federal court proceedings. Is everything you just relied on to explain that to Judge Howe in response to his question, is all of that in this record?
Yes.
Okay, very good. Second, even if everything you've just said to this point is correct, it seems to me that doesn't do anything to solve your service problem, that the motion in the federal court was not served on others, which I think is a deeper problem with your position. Maybe you could skip ahead to that now.
Okay, sure. So what you're referring to is under the declaratory relief statute.
Mhm.
It says that if, and let me just, I have it written down here too, but when declaratory relief is sought, all persons shall be made parties who have or claim an interest which would be affected by the declaration, and no declaration shall prejudice the rights of persons not parties to the proceeding. So what happens here is that, and the analysis is that the association or Moss has to show that they have an interest that would be affected by the declaration. At the time that Mr. Hoover filed his motion for declaratory relief, he had no idea that either Moss or the association were making any sort of claim to having declaratory relief. And
But what if there's no Moss? Why wouldn't it affect them either way? Whether or not they had successfully installed like a rump declarant or not, aren't they still affected by who's the declarant? And also, this doesn't get mentioned, and who has the community master planner rights both, because that's all being assigned. Wouldn't they be affected regardless of the state of play of who's occupying that position?
well, I think that the nature of the relief that Mr. Hoover is requesting is nobody was disputing the fact that we've got these CCNRs, ERCC is a declarant, and what can happen under the CCNRs is an assignment. We weren't asking the court to determine that issue. We were asking the criminal court, not by we, I mean, Mr. Hoover was asking the criminal court, in light of these criminal proceedings, which the association and Moss have nothing to do with, I need to know how do these proceedings affect my rights under the CCNRs? And also,
I mean, speaking as Hoover.
I'm sorry.
You said affect my rights. You're talking
I
about,
apologize.
just making sure I'm following. Sorry, counsel.
Yes, I'm speaking as Hoover.
Right.
And so that was the nature of his inquiry related to the criminal proceedings, the effect of the criminal proceedings on the CCNRs, and it did not directly affect any sort of purported interest that Moss and the association have. To me, I feel like, and maybe this is a poor analogy, but how do you define interest? It's got to be a justiciable controversy, right? Like I might have an interest in making sure that my neighbor trims his bushes, but that's not a legal interest. And I think that a justiciable controversy would be if the association and Mr. Moss were able to say, we have a competing interest for declarant rights. You here in this criminal proceeding are trying to obtain declaratory relief as it relates to these declarant rights.
Well, see,
But even if what your client wants is to say that Hoover did have those declarant rights, and if he were assigned those over his own properties and he was the master planner over his own properties, doesn't that affect the rest of the people who come under the CCNRs? Because then you've got a broken up declarant where there are two declarants within that community. There are two master planners, and Mr. Graham could do whatever he wanted as the declarant over his own property. So don't they have an interest in making sure that the CCNRs that call for one declarant, one master planner, don't they have an interest in that, that regardless of whether they have a competing justiciable claim about who the declarant is, doesn't just the fact that it could be broken up affect them in a way that they have an interest in it?
Well, I think another thing that I go back to is the CCNRs and seeing if the CCNRs gives the association or MOS the right to intervene in the process whereby a declarant is assigning declarant's rights to a third party. There's nothing in the CCNRs that gives them that right. So they wouldn't have standing to bring that sort of a dispute.
well, they wouldn't have contract-based standing based on the contract gave them the right to intervene in someone else assigning declarant rights, but they would have standing in a more general sense that they're all parties to a contract, the CCNRs being a contract, and it affects the use of their neighbor's land, and it affects the value of their land. What if you want to build something that violates setbacks, or you want to consolidate four properties, and you get to be the community master planner who decides that, but you're going to decide that, and maybe no other hypothetical community master planner would decide that. I mean, it seems to me they have like a justiciable interest, right? Because they have some potential for their property rights or exercise of enjoyment of their property to be injured, no?
So then you're saying that what Mr. Hoover should have done is to provide notice to everyone that
Well,
was in the community.
let's put it this way.
The owner.
If it would be a very different situation if notice had been given to all the other persons who could potentially be affected by a change in declarant or a change in master planner rights. If notice was given to all the lot holders, then it strikes me you might not be in this position today because everybody would have acquiesced in what your client was doing. But that didn't happen because only two people got to hear about it specifically, not all the lot holders. Yeah.
Well, I hear you. And then as you say that too, it occurs to me that while the association and Mr. Moss were acting behind the scenes in order to obtain declarant rights, they didn't provide notice whatsoever to Mr. Hoover or Mr. Graham concerning their conduct. But again, I understand that we're talking right now with regard to the notice requirement.
And you said what should he have done, noticed all the property owners, but they didn't even notice the association.
Right.
I mean, it's not a question of you should have noticed, 700 people, but you could have noticed the association who held the declarant rights the last time there were declarant rights, and they weren't noticed. So whatever they did could have given notice to the property owners. They could have taken a position as the association vis-a-vis who was going to be the declarant over the community and the master planner. So
Well, just a correction, the association didn't hold declarant rights. The association never held declarant rights.
whoever the last holder of, I mean, the Elio 11 or however you say that, I'm saying he didn't notice anyone outside of the one property owner who wanted them over only his own properties. And so there was someone else. Anyway, I was just pushing back against well, should we have noticed the universe of people, or were there certain entities or organizations that they could have noticed that would have, again, like Judge Jacobs said, changed the nature of any decision that was made?
I mean, there was an association, correct?
Yes.
Who knows who operated the association, but it was there. Shouldn't they have received notice?
Yeah, there was an association at the time, but the association's brief was over phase 1 and phase 2. Mr. Graham's parcels over which he was seeking declarant rights were not in phase 1 or phase 2. The parcels were outside of those phases over which the association had control. He did have a single lot within lot 80, however, that is in phase 1.
And they're all subject to the same CCNRs, roughly speaking, aren't they?
They're subject, all of his property is subject to the CCNRs, not all of his properties are subject to the association's power.
Right, but the CCNRs are a contract that bind together all the lot holders of phases 1, 2, and 3, right?
Right.
Okay.
And and we can get off this point, but is there something more you want to say about why not being in phase one or phase two is important to the last set of questions we were asking about notice?
Um, just the idea that if the association, first of all, number one, the association didn't have declarant rights at any point. So it did not, there would be no reason for Mr. Hoover to think to give the association on that basis notice of his motion for declaratory relief. But also, at the crux of their request for declaratory relief was Mr. Graham's property, and Mr. Graham's property is not within the reach of the association. Another reason why we wouldn't think,
Yeah.
Hoover and Graham would not think to include them in the motion for declaratory relief. And because I feel like this sort of dovetails off of the discussion that we've just had, I think it's also important that to note that even to the extent that Mr. Graham, the issue of whether Mr. Graham has declarant rights over his properties was not even a part of this litigation. There still would remain the question of whether the association and Mr. Moss violated the title as well as ARS 33.1, et cetera. There are still claims that need to be decided. In particular, one of the most detrimental, the Judge Jansen's actual finding that the association should have declarant rights. What do we do with that?
What about the fact that they had advice of counsel telling them that what they were doing, even if mistaken with the recreation of documents, was valid? I mean, doesn't that get them out of liability under 33-420?
See, no, I don't believe so, because I think it cites any sort of authority that would say that advice of counsel is a defense to liability under 33-420.
But don't they have to violate the statute knowingly? Isn't that a requirement? Isn't 33-420, doesn't it speak of knowingly?
Yes.
Okay.
They did have countervailing evidence that shows that they knew.
Okay.
They were presented with a Bennett letter. The Bennett
Mhm.
letter, very extensive letter explaining, look, if you do what you're about to do, which obviously Mr. Graham had no idea what was up their sleeve, but when they were poised to execute and record that 2018 assignment, they had in their back pocket the Bennett letter. They knew what was coming for them if they did that, but they chose to do it. And they say, well, we did that on advice of counsel.
So knowingly here doesn't mean that they're lay people. They get a lawyer. The lawyer says this is legal, but your lawyer has a letter that says it's illegal. They should have relied on that, and so that doesn't vitiate the knowledge requirement.
I think that unfortunately sometimes counsel gives poor advice,
Sure.
and the people rely on that poor advice, and it leads to liability. And there are recourse against that counsel,
Mhm.
and sort of lay in the bed that you made or whatever the saying is.
Mhm.
If there are no further questions,
Okay,
thank you very much.
thank you. When you're ready.
Good morning, may it please the court. My name is Rita Bustos, counsel on behalf of Thomas and Nancy Moss. I'm here with Quentin Cups, who is counsel for the El Rio Community Association. We filed a joint answering brief, and I will be presenting the oral argument on behalf of Mr. Moss and the association.
Counsel? Just as keeping with the conversation we were having with counsel, I apologize for not hanging back 2 minutes, but could you please expand upon, because you sort of said in your brief, you kind of treated as self-evident the fact that there were rights that were disserved, as I was discussing with your opposing counsel a few minutes ago. Could you put some more meat on the bones of why under 1841 they might have been required to serve either the association or all the lot owners? Could you expand on that beyond what's in your brief, please?
Oh, yes, absolutely.
Thank you, counsel.
Yes, and that's actually a very essential, one of our essential positions. First and foremost, the district court orders did not grant the rights. That's our first position. And then second of all, even if they did grant these rights, the orders would not be valid and enforceable because of the lack of notice. And of course, the association and, well, at the very least, the association, but also the property owners would require notice under the statute because their rights are completely Whether or not they're fragmented at this point, I don't know how they got to that point, but the CCNRs do talk about just one declarant and one community master planner, which is over the entire community. And the powers of the declarant and the community master planner are pretty vast. They can, determine tract declarations. They can determine what is built on the property. This was actually very important for phase one, which is part of this. One of the properties of Mr. Graham wants it to get declared a community master planner rights over was in phase one, which was completely developed, right? So if there's a new declarant and a new community master planner that comes into phase one, then who knows what that community master planner and declarant will do with that property in phase one. So of course that's going to affect the association, and that's going to affect the property owners, especially in phase one. So of course those parties did have an interest and were required to be made parties to the declaratory relief that was sought in the district court, but also at the very least provided notice so that they could intervene, right? So at the very least, the statute talks about providing notice to interested parties so that maybe they could have intervened in the case as parties. So
that's really thorough on the one lot that Graham had in phase one. Can you speak to the fact of, well, what about the fact that it's in phase three? Because you get notice when you're an interested party, which is a bootstrap back to, do you really have a substantive right that's being affected? So what's your position with respect to, even if it repeats part of what you've said, the lot's in phase three now?
Well, of course, again, I think it goes back to the same argument, Your Honor, is that under the CCNRs, the community master planner and the declarant have these pretty expansive powers to do what they want with the properties, or to determine tract declarations and all of these other things that they're able to determine under the CCNRs. And of course, everybody in the community, whether or not they're in phase 1, 2, or 3, can be affected by what happens, for example, in phase 3. Or the association can also be affected by what happens in phase 3. The CCNRs are in place specifically to determine, what happens in the entire community, and the whole community should be able to have a say in what happens, and especially the association, who are voted into that position in order to oversee what happens in the entire community.
So the phases don't matter.
Well, I don't know necessarily if the phases don't matter.
Well, do they matter in relation to the arguments that you mentioned? Right?
Well, I don't think they matter in relation to the arguments. I think that the strongest argument is obviously for phase 1, which was fully developed, and I think that's enough, honestly, to say that the properties were fully developed in phase 1. So of course, if a new declarant and community master planner just comes in and they can go ahead and do whatever they want with that property in phase 1, that's going to affect the other property owners in the community and the association.
So like if everything was built Santa Fe style in phase one, you still might not want to have a bunch of English Tudor brick manors in phase 3 because it might hypothetically affect the marketability of the phase 1 lots, right?
That's a perfect argument, Your Honor. 100%, absolutely. So again, Your Honor, just going back to what this case is fundamentally about, appellant's entire argument and all of their claims just hinge on the misinterpretation of the 2 district court orders, right? Because if they cannot prove that they actually have these declarant and community master planner rights, then all of their claims fail. And that's exactly what the trial court found here, based on substantial evidence that the district court orders simply did not provide or grant the rights that appellants claim that they granted. And that, again, you can just look at the plain language of the court orders to see that that's the case. And that's something that appellant pointed out in their reply brief. You're supposed to look at these orders via their plain language.
What if we reject that position? What if we think the district court gave the rights?
Well,
Do you lose then?
No, we don't, because we go back to the notice requirement under ARS 812-1831. Again, even if the district court orders do grant those rights, they are not valid or enforceable because of the lack of notice.
Well, Judge Jansen was pretty skeptical about the district court proceedings, wasn't he? I mean, he seemed pretty clear that, he thought that the district court overlooked a number of important things, that there was collusion with Hoover. I mean, I see a lot of indications that the district court orders received a very unfavorable view from Judge Jansen.
Well, the orders, I mean, I guess maybe he was thinking about the proceedings that he believed, and maybe it's because when you look at the plain language of the orders, they are so simple. He probably believed that maybe the district court did not have all of the information that it needed to make proper determinations about what rights actually exist.
But this is the criminal court that oversaw the plea agreement itself, and they went back to the place where that agreement came into being, and the judge said, "Sure, that's right. You have declarant rights. You can give them to someone else." I mean, you make it sound like it's a really easy call about these district court orders, but they give that man who asked specifically if he could have declarant rights to pass on to Graham on those properties the first order. And he said, "Sure." She said, "Sure." So how would anybody on the outside read it any other way but to say, I'm trying to get these rights. The person under the terms of the plea agreement says, I'm not really sure. I know that they're supposed to be a receiver or a marshal, but I don't see anything happening with that. And they do what, if you're in Hoover's position, seem like all the right things. You're not going out there on your own to try to pass these rights along. And they get the blessing of the district court who took the plea agreement. And you have the state saying, fine with us. And you don't have a receiver coming in and saying, no, I'm the receiver. I have these. I mean, all of that, you make it sound like it's really clear that these were kind of sketchy orders. They weren't sketchy. They were simple on their face. You can give your declarant rights to someone else. And hey, by the way, a year later, if other people come along, I don't want to be involved in this anymore. The receiver's not doing anything. Other people need these rights. Whoever asks, you're free to give them. How would anybody read that differently?
Well, Your Honor, I think that that's, with all respect, an oversimplification of what happened here. The district court basically said, Hoover, you can give whatever rights you have to Graham.
Well, they say declarant. I mean, it's not just whatever rights you have, whatever someone else determines you have them. I mean, especially I think in the first order, it's your declarant rights. I understand your argument is, well, you don't have any declarant rights to give, but he knew what they were asking. She knew what they were asking. She gave her blessing to do that in the form of an order that says, yes, you can do what you're wanting to do.
Well, Your Honor, of course, we disagree with that interpretation. And yes, it was actually the second order where they specifically said, defendant may execute an assignment of declarant rights to any property at El Rio Country Club when requested. However, it does not define what rights Hoover has. And it's important to go back to the motion for clarification and then the government's response to the motion.
Is that in the record? Other than the cites that you made to testimony of Mr. Moss, is the motion practice on that and the court's order in the record that the Superior Court had?
The government's response is in the record, and you're right, the physical documents, and we've requested judicial notice, the court has not ruled on that yet. The actual motion for clarification and the court's order on the motion for clarification, the physical documents were not in the trial court record. They didn't become a trial exhibit, but they were discussed with the trial court judge at a status conference. Actually, the parties requested that the case be, the trial be continued so that they could seek clarification from the district.
Well, what are we supposed to do with that? What are we supposed to do with documents nobody puts in the record that get discussed verbally with Judge Jansen in a status conference? I mean, we can't really make findings predicated on something that out of the record, can we?
Well, Your Honor, that's why we requested, out of an abundance of caution, we requested that this court take judicial notice of the motion for clarification, and more importantly, the district court's order, which are certainly documents that this court can take judicial notice of because it was information that was discussed in the trial court. And I guess more importantly, the document that is in the record doesn't really make sense. The response of the government to the motion for clarification doesn't really make sense unless you have the motion, which can be judicially noticed, and then you have the
We see things in the record that don't make sense all the time. I don't know that we would say that we take judicial notice of the things that would bring context to things in the record that we don't understand why they're there. And what you're telling us is the transcript of the status conference in our record?
No, the transcript
Okay.
is not.
So you're telling us that you discussed something that we don't see the transcript of, so we don't know what particular things were discussed, but you want us to take judicial notice of an order that says things that we're not sure the trial court judge ever heard or saw.
Your Honor, but I guess the bottom line also is, even if you don't consider the motion and the specific language of the order, the decision on the motion for clarification is certainly within your purview. So you know that the district court refused to clarify their orders. And we do have the government's motion specifically, which says, and again, this is completely within the record, and they're saying the orders require no clarification. This court will not enter, oh no, I'm sorry, that is the district court's order. Disputes regarding what declarant rights Mr. Hoover had to convey at the time he purportedly conveyed them were not before the court when it issued its orders. The orders do not enlarge or diminish whatever declarant rights Mr. Hoover had. They merely permitted Mr. Hoover to execute an assignment of declarant's rights without defining or enlarging what those rights were. That document is in the record, and that is a document that this court can consider. And our argument to this court is that it was within the trial court's purview here to decide what rights Hoover had based on the plain language of the orders. And I understand Your Honor's concern. There was a request for declaratory relief, which listed very specific things that Hoover wanted the court to decide. I don't know what the district court was thinking. I don't know why their orders aren't very specific as to, okay, yes, well, I'm granting you declaratory relief on 1, 2, 3, 4, 5. They did not do that here. They simply said, basically, Hoover, whatever rights you have, you can assign them without deciding what those rights were. And then it was the state court here, the trial court decision here, to determine what those rights were.
Well,
and he had,
how did the district court state its order?
how did they state their
Yeah, I mean, what was the phrasing that they used to?
So the first order specifically said that Hoover, and this is also important too, is that it talks about, it does not talk about ERCC, and it doesn't authorize him to act on behalf of ERCC, and at that point in time, he didn't have the rights to act on behalf of ERCC, who was the declarant at that point. And it says Hoover may execute an assignment of his rights to allow Scott Graham to attain declarant rights over parcels that he owns. That's the first order. And then the second order, admittedly, is a little more clear. Defendant may execute an assignment of declarant's rights to any parcel of property in El Rio Country Club when requested.
Those both seem pretty specific to me. They may not be as specific as we now would want, but they seem they are Hoover's rights.
And exactly, Your Honor, yes, but then what are those rights? And it was the trial court's determination here to determine what those rights were. And that's what the trial court did after a 3-day trial, looking at all of the evidence. And he had, and that's obviously the standard of review here, whether there is substantial evidence to support the trial court's verdict, which of course this court is not going to overturn unless these findings are clearly erroneous. So even if there is evidence in support of the opposite position, as long as there's substantial evidence to support the trial court's finding here that Hoover did not have these rights to assign, then that's enough to sustain the trial court's verdict.
I mean, I realize in a sense it's not our job to decide what the district court's order covered, but what if the order then had, the district court's orders essentially had no effect then?
Well, Your Honor, I guess if that's the way that we want to see it, then that's the way that we have to see it.
So the district court just broke.
Well, I guess, Your Honor, and again, there are a lot of unanswered questions with this case. For example, your question right off the bat to my friend over here about the receiver. Where is the receiver? Well, you know what? That's actually not in the record, and that's not an issue in front of the court. So again, that's the same thing here. Well, what did this district court do then? What do these orders do if they don't grant the rights that appellant says that they grant? Well, honestly, that's just not something that is important or relevant to the issues here. The issue here is the trial court had an obligation because, okay, appellants filed this claim. It was a quiet title, a recordation of false documents, and a declaratory judgment. Those were the three claims that were in front of the trial court to decide. And he had to decide, the trial court had to decide based on the substantial, he had to interpret the district court orders, and the only way to interpret the district court orders is to determine what Hoover's rights were. The trial court could not just say, oh yeah, I'm going to take this at face value, Mr. Graham, that Hoover had all these rights.
Well, or actually, you spent basically your entire argument on the proposition that the rights, were not there to be granted. It could be the case that rights were there and validly granted, but that the service problem wins you the case. You don't seem very impressed with that hypothesis. But I really want to ask you about something none of us have addressed that's also about things that aren't in the record, which is Mr. Moss's $78,000. So what's the authority? I was kind of surprised to see in a brief the idea that you could file the $78,000 fee request and not contemporaneously serve it on them, and that somehow that's okay because it gets emailed like 20 days later. Is there any case authority that tends to support that? Because it seems like Rule 5.1C1 says, after a complaint's filing, if a document must be filed in a specific time, it must be both filed and served. It seems like you got to do those things at the same time, but your brief kind of tells me otherwise.
Your Honor, and again, we're going to the attorney's fees issues. Any technical issues with the service of Moss's fee application, well, the authority is that the argument that Graham was making is that he wasn't able to respond to Moss's fee application and all of the evidence contained in Moss's fee application because he did not have notice of that.
That's not my question, counsel. Your brief does that too structurally. It tries to say basically, well, you can tell that they got it, you can tell that they know stuff. I'm not talking about their obligations. I'm talking about your client's obligations. What is the legal authority for the proposition that in an attorney's fees request for $78,000 like this one, that you can not serve it and then 20 days later email it to them, and then that's sufficient awareness on their part to constitute service under Arizona's rules? Is there a case like that? Because I don't know of one.
Yeah, and I think our argument is that the application was served when it was put in the mail, and that's in our...
20 days later, though. I'm talking about the timing. 20 days later, right?
No, it wasn't 20 days later. He put it in the mail, and I have a timeline.
Mhm.
To be honest, I can't remember the exact timeline.
Sure.
Of course, Your Honor can go back to the answering brief and review that. But the service, the application was put in the mail, I think only a few days after it was actually served.
I thought you...
Or filed. So service by mail means service, and that's what we have in here. And plus, again, we can go back to the Klein versus Klein case, which talks about strict technical compliance with the rules of service may be excused when the court has acquired jurisdiction and the party receives actual timely notice. And I think that's part of our argument here. But it's also important to note, just for the attorney's fees issue, that appellants did not argue about, or didn't argue that the amount of the attorney's fees was unreasonable here, and we pointed that out in our brief, unless the court has any other
I think they're saying they didn't get proper notice of it, such as would allow them to respond to it timely as the rules required. I think that's their argument.
Thank you.
Your Honor, the documents that I spoke about from the district court are in the record. I would point you to Trial Exhibit 22, Trial Exhibit 23, Moss's Trial Exhibit 11, and then Index of Record Exhibit 8. The proceeding, the motion for declaratory judgment proceeding in the district court was between Moss and, was between Hoover and the government. And it's Hoover asking the government, what rights do I possess? And again, I hate to beat a dead horse, but the interests that are at stake there are between the government and Hoover, and request to court to clarify in light of the criminal proceedings, what am I or not am I able to do or not able to do? In terms of, yeah, I do think that there is a distinction between having Lot 80 of Mr. Graham's property in Phase 1 under the jurisdiction, so to speak, of the that are not in phase 1 or phase 2 and are outside of the association's jurisdiction. I heard it said, we don't want a declarant doing whatever it wants. And I can certainly see that, but perhaps there is a nuance between, under the CCNRs, the idea that who gets to be the declarant is not a decision that is voted on or a decision that includes in any way any of the owners or the association. That is a decision exclusively of the declarant, in this case ERCC. And so that's the way it is. And I think that if a declarant is appointed or becomes declarant through an assignment, and there is afterwards some sort of a dispute in terms of what that declarant does, then you deal with that dispute at that time.
Put aside, though, that's the downstream part. I went to that first, and it's kind of the second level argument of like, well, substantively, you could have wacky things going on that are inconsistent with each other. What about the top level of her argument, which is just that you can't have two declarants. You can't have two competing master planners at the same time. What about the idea that structurally they have a right not to have that, regardless of what comes out of that machine?
So before this dispute ever began, we had many declarants. We had other declarants. We had ERCC, and then in 2011, before our dispute began, we had DAB Properties as another declarant. We have DevTron as a declarant. We've got
Simultaneously or consecutively? Wait, did you simultaneously have 4 declarants, or were they consecutive declarants? Okay, not simultaneously. That's the argument you're responding to.
Oh, I'm sorry, no. Simultaneously, but they consecutively in the timeline obtained declarant status. So now, yes, simultaneously in the pie that is the development, you have got DAB Properties, Jones 1, DevTron, and ERCC, all declarants. And in terms of community master planner rights, when you look at the briefing and the motion for declaratory relief, it was clear that we were asking again, Hoover is asking to assign not only declarant rights, but community master planner rights. When you look at the partial assignments, community master planner rights are included in there. And the function of a community master planner, they work in tandem with the declarant. It only makes sense for the two of them oftentimes to be the same party, which is the case under the CCNRs here. You've got ERCC as declarant as well as the community master planner. And by the way, the declarant is the one who gets to designate who the CMP is. So if you find that Mr. Graham has declarant rights, well, he's going to be able to designate who the CMP is for his properties. And that's really key because it's going to allow him to develop his properties, mostly his parcels is what he's concerned about, the way that he wishes to, so he can make use of his.
Okay, thank you. Thank you both for your arguments. We will take the matter under advisement and issue a decision in due course, and we're adjourned. Thank you.